Welcome back from lunch, and we are really honored to have with us today two people for whom you may disagree, you may agree, but if you're in this space, you must be aware of what they are doing when it comes to regulating and enforcing in the privacy sphere. The GDPR new regulations that are in effect have dominated, I think, privacy and investments around privacy for companies around the world over the last year. And there is not a day that goes by that I do not get calls from interested companies as to what is going on in California and how are they going to interpret and enforce their new law. So we have the two lead officials that we mentioned earlier, Andrew Jelenic who's the GDPR enforcer, and Xavier Becerra, who is the Attorney General for the state of California. Please join me in thanking them for being here with us today. Let's jump right in. We have in Europe, we have an approach where there's uniformity, a baseline uniformity across multiple countries in the form of the GDPR. Here in the United States, we have no federal data, we have no federal reporting requirement, and instead, which is a boon to lawyers, but perhaps not to anybody else, we have nearly 50 different approaches across states. But that does allow for experimentation with new statutes and new approaches. So I thought maybe I'd turn to each of you as an overarching, why do you think having a uniform model versus laboratories of experimentation is the better approach?
Shall I start?
Yes, please.
Okay. First of all, thank you so much for the invitation. It's an honor for me to be here as the chair of the European Data Protection Board. It's really interesting to be here at your Cyber Summit and to be able to explain one of the core principles of the GDPR. And one of the core principles of the GDPR is that the European decided to have one common law which is applicable in all 28 countries, which is the European Data Protection Regulation. And I think now the regulation is into application for the past 5 months, and I'm here to share with you our experiences, because in former times we had a patchwork, and so it was not so easy for the companies to comply with all the 28 laws of data protection all over Europe. And now the companies just have to follow one set of rules in all of the 28 countries and only have one interlocutor as supervisory authority if they have a main establishment in Europe, if they are doing business in Europe. So it's easier for companies too, and for complainants it's easier too, because they don't have to travel from country to country if they have a complaint. They just can file their complaint with their data protection authority. So it's an advantage for both sides.
John, if I can start by saying thank you to you and to Aspen for inviting. Pleased to be here with Chairwoman Jelenic. It's going to be interesting to watch as GDPR really unfolds in Europe, and now with California with its privacy statute in place. We'll be looking to work closely with Europe and to learn from their best practices. I would simply start by saying that I think all of us recognize that at the end of the day, what we're trying to do is make sure that we're protecting choice, we're giving people control over their own personal data, that we're providing transparency when it comes to the use of that data, and we're not stifling innovation in how we can make best use of that data, because I think we'd all agree we live now in a digital world and a data-driven economy, and he who controls the data has wealth, and she who controls the manipulation of that data will end up having the wealth and the power. And so I think we want to make sure we get this right. With regard to how to do it best, I don't think there's a verdict yet. Certainly we're going to find out from Europe how it goes. I would simply say that here in California, we don't typically wait for the federal government to tell us how to do things. And had we waited for the federal government, we probably still would have no notification laws in this country to let consumers know when their personal information has been breached. And California was the first state to enact a breach notification law, and that was back in 2003 or so. Now virtually every state in the nation has one. The federal government still has no statute protecting the breach of information and notification to consumers. So if the federal government is not going to be there to innovate when it comes to policy, then they should at least do no harm and not get in the way. But at the same time, we recognize that there is an interest in making sure we do this well, because we want to make sure that there's a good standard in place for everyone, not just in California. The verdict is still out how to best do that, and I think now you have two good models to look to see where we might end up going with GDPR and now with California's privacy law getting ready to be implemented in about a year and a half.
One difference between the approaches between the California state law and the EU's approach in GDPR is consent. So Europe has chosen to not rely on consent as the defining principle and has many areas in which consent is not sufficient. The California law does rely on consent, and I wanted to hear what you think are the pros and cons of each approach.
So understanding that our law was essentially a compromise of a proposal that was on our ballot and would have driven a result without the type of give and take and compromise you have in a legislative process, the result was a statute that had to move quickly through the process in order to avoid the drawn-out, very expensive fight we would have seen in California's election this past November 6th. Look, I would tell you when it comes to the issue of consent that the most important thing to remember is, are we protecting that choice, that control of consumers? There are probably different ways to get that done. We hope to be able to find that sweet spot when it comes to the regulations we have to draft. But at the end of the day, what I think we're going to have underpin our direction is the issue of providing our consumers with both choice and control over their data.
Consent is a basis of the GDPR, but not the only basis. You also can process data when you have a legitimate interest or when you have a legal basis. And consent can be part of this. And some of the companies can rely, and in some circumstances you can rely on consent, but not always you can rely on consent. And the most important thing is, if you rely on consent, the consent must be freely given. And it's not possible under all circumstances that the consent is freely given.
Follow up on that a little bit. Raise your hands if post-GDPR you've gotten an announcement asking you to click through on a website. All right. So pretty much everyone, and I'll say for myself in this field, spent a lot of time on cybersecurity. I got something like 100 of those notices, and I just click. I'll admit it. Do you think that's working the way you intended, and how do you balance the consumers from just being overloaded with the desire to get them important information?
First of all, many of these notices were not necessary, because most of them you just got because people didn't read anything. And it's not a question if you are based in the United States or in Europe. It was the same in Europe. The point was, if you already gave consent to the processing of your data in a specific field, they didn't have to send it again to you. But only if there would have been a renewal on a different purpose to process it, then you should have given the consent. So most of these things you didn't get in vain, because maybe it was time for like a spring cleaning also of your data, because sometimes you didn't even know more that you gave your data to them to send you some information. So if you didn't give consent again, you don't get so many stuff you really don't need, I think. But the point is, it's only a question if this consent given was really necessary. In most of the cases, it wasn't necessary.
I'd just add that anybody here purchased a house before? Have you applied for credit? Have you been asked to consent to give your Social Security number? Social Security number was never created to be an identifier. It was meant to be a way to track your Social Security contributions. And so at the end of the day, when you're ready to retire, we'd have a way for the federal government to let you know how much you put into Social Security and how much you'd get back. It has become essentially the nation's identifier. And so you can't do certain things without giving up your Social Security number, which if you give it up and it is breached, and if someone gets a hold of it, you may find that you bought a whole bunch of homes that you were not aware of. And so the issue of consent is a slippery thing. At the end of the day, you want to know that people really do control that decision, and it's a choice they freely make.
It's good. It's a segue, actually, following up on the Social Security number, because that's an area which, in part, was driven by inadvertent regulation. So the financial sector was required to use Social Security numbers as a way of identifying.
Actually, John, there's no federal law that requires that the Social Security number be used by any financial service company.
That's absolutely true. But when it was first adopted, it was through regulation. It was through the interpretation of regulators.
It was seen as a convenient way to do it.
Yeah.
But it's never been required by federal law or regulation that the Social Security number be used. But it was a very convenient, and quite honestly, it was as close as you could come to having a reliable method to document someone's personal data, who they were.
And I wanted to follow up on it, because we have Rob Joyce here, who is perhaps the last cyber czar or coordinator. From my perspective, hopefully not, but that position no longer exists. But I know he's memorably talked about how many times his Social Security number has been stolen in different incidents, and he's received notice, appropriately so. And I wanted to ask, how do you balance? It's a similar question to consent, but these days, I know my daughter's first letter that was addressed to her by name was telling her that her identity had been stolen as part of the OPM hack. As a consumer, what do we do with the fact that we're receiving this information, our Social Security number has been stolen? And relatedly, how do we incentivize moving to a new form of identification that is more secure?
I think the chairwoman has a good answer for that one, because I'm not sure I do. I can simply tell you that whatever that identifier is, there has to be consensus that that's what will be used, and then we have to put every bit of architecture that we can to provide security around it, because the last thing you need is for it to become obsolete before it gets out there universally. How you do it, it's a big question, because it'll cost quite a bit of money, and that's why Social Security number has become that identifier, because it's out there, it's ubiquitous. Everyone must have it at birth. Now you have to have a Social Security number, and so it's easy. The difficulty is that the Social Security system will tell you from the get-go, they're not equipped to have the number they assign to an individual in this country be used as a national identifier. They were never set up to be the Fort Knox of that particular identifier. And they will tell you that their computer systems are probably similar to the ones that you threw away 15 years ago. And so it's a difficult task for them, and we have to understand what it would take to navigate to get to a national identifier.
Andre?
Social security number is not a national identifier in Europe.
Right.
So you just have the right to use this a social security number for the purpose you process them. It's not an identifier for Europeans, just for their social security and for nothing else, not for a mortgage, not for anything like that.
But what should be? You still need to identify people, so what should companies be using for an identifier?
I think it depends on the use of what you need for the processing, which data you want to process, and for which use you process the data. Then you have to ask people to give their data, but not more than you need. And I don't see any use for the social security number if you're not in healthcare. It's quite a different concept.
Following up on the idea of people getting multiple notifications that they've been compromised, in both the California approach and under GDPR, there's a focus on notifying consumers. Earlier today, we've heard from law enforcement and intelligence agencies that they want to encourage companies to come in and work with them collaboratively, and that they're facing challenges in having that occur right now. How do you balance the notice regimes that currently are pushing notice out to the public that in the US often results in class action suits, under GDPR could result in fines of up to 4% of profits, with the idea of treating the company as the victim?
Question?
Sure.
Okay. Data breach notification under the GDPR, so the company has to notify the breach after the 72 hours. That's the first notification to the Data Protection Authority. And if necessary, if there is a risk for the personal data of the affected person, they have to notify to the person too. But this doesn't mean that this is the end of the process, it's just the beginning of the process. And if there are harms that national security can be affected, you can make exemptions, but it's not for sure and not always like that, because if companies are affected by data breaches, you just have to tell the persons who are affected. You had all notice of Cambridge Analytica and things like that, and I think it's really important that people can have the information about data breaches. And there's no use to hide, because if you lose the trust of your consumers, you're lost in the universe, because not the data are going to be the gold of the 21st century. I think it will be the trust of your consumers and your customers. And I think you have to be really careful with these issues.
So let me take this approach and try to respond to that question. Because we're in this world because consumers want to have access to all sorts of information. There are a lot of companies that want to do good in providing information, but they also want to do well. And so they profit from providing this information. And our governments want to make sure that we have harmony and no one gets, swindled, taken advantage of. So I would put in these terms. You have to distinguish when you're talking about when breaches or an offense has occurred. Is the offense criminal or is it an accident? And there's a big difference. Criminal means you intended to do something that was against the law. Accident meant, oh gosh, we didn't think someone could access that information and then send it out to a whole bunch of folks. We didn't mean for that to happen. Let me take you had the mens rea, you had the wrong intent in mind. So criminal, I think you have to look at a different perspective. In any crime, you got a perpetrator, you got a victim, and sometimes you got an accomplice. Okay, you decide where you fall. Are you perpetrator, are you victim, or are you an accomplice? I would say to any company that collects data, remember, it's like any parent who wants to have a baby. You wanted this baby. You wanted to be able to collect that data. You drop a baby, was that an accident, or is that a crime? You wanted to be able to collect that data. You wanted that baby. And so if you drop that baby in the wrong way, you've committed a crime. Or if you've helped someone, you've been accomplice in someone dropping that baby, you're an accomplice to that crime. Maybe you can figure out how to classify yourself as the victim in dropping the baby. But a baby was dropped, somebody was hurt. Who's responsible if it's a crime? If it's an accident, then you drop a baby, you better have a really good explanation of, if you're a responsible person, why you drop a baby. And so I think if you look at it from the enforcer's perspective, crime versus accident, if it's a crime, perpetrator, accomplice, victim. And I will say that anytime you take up personal data that's valuable, someone's always going to try to gain access to it. So you're always subject to somebody trying to commit a crime with the baby that you wanted. And so our job is to make sure that you're responsible in the way you handle that baby. You decide whether you're perpetrator, accomplice, or victim.
Okay, push on that just a little bit before we follow up, which is, maybe it's my background as a former prosecutor of those types of offenses, but if someone ripped your baby out of your arms, we would provide them a victim advocate and go seek to prosecute the person that stole that baby. We would not think of charging the grieving parents. And I recognize there could be a negligent, but that's the case where there's not a clear safe harbor under either regime that says you're a victim in this space. And so how do you balance?
That's a great example. But if you walk into a room and you know there are a whole bunch of convicted baby snatchers in the room, it's all based on the facts, right?
And you have to take care about your baby. You have to take
care.
care. And you shouldn't leave it alone.
There's a tolling provision under almost every U.S. state law that says if federal law enforcement requested for investigative purposes that you can wait a certain period of time. How is that handled under GDPR?
Under GDPR, if there is a complaint, we have to handle the complaint. There are national complaints and there are cross-border complaints, and we can't pick out and choose which complaint we are going to handle. We have to deal with all the complaints.
And there's a tension a little bit that also has gotten explored today between privacy and security. And in particular, I know when it comes to GDPR, and this may start being an issue with the new California state law as well, companies are struggling a little bit with some of the provisions they put in place for security purposes that are recommended and in the U.S. sometimes required by regulators in order to have an active security program that are in tension with some of the privacy rights for employees that are preserved under GDPR. How do you balance the needs of security versus privacy? And ultimately, obviously, for privacy, we want to encourage security.
I think it's a question of balancing. And I think privacy and data protection is a fundamental right. And security is also very important, but they are
Is it
not.
also a fundamental right?
Yes, you have to be secured by the state. But the point is, there is a basis for both, and there is no security without fundamental right of privacy and data protection, because you have to be secure on the one side, but there is no security if you have no rights on the other hand. So I think it's very important that you have both in mind when you are acting.
I would agree with the chairwoman on that, and I'd simply say in California we know how to walk and chew gum, and so you got to have both. You can't. In fact, in some ways, I don't think you can have one without the other. And it's just a matter of trying to have that tango. Tango is a beautiful thing if you both know how to do it. It can look really awkward if one party doesn't know how to dance it well. And so the most important thing we can do is recognize that this is a dance among three: consumers, the private sector, and our government. And we should learn how to do that 3D tango real soon, because everything's moving in nanoseconds now. And the old adage of buyer beware, it can't keep a pace with the movement that we're seeing today in this digital economy.
And following up on the movement idea, as we move towards artificial intelligence or increasing advances in machine algorithm learning, we're seeing, it's been discussed a little today earlier on the China panel, that those who may not share our values are proceeding very quickly at the development of artificial intelligence that then could be the basis for what the rules are for the world going forward if they're the first to develop that technology. So there's an incentive for the West to be able to develop in machine algorithm learning, artificial intelligence. At the same time, that is an area that raises deep privacy concerns. And so currently, do you think the California statute, do you think GDPR, does it reach the right balance that's going to allow companies to achieve gains in AI, or have we overweighted it right now towards caution?
I just want to point out very shortly, as the GDPR is technologically neutral, it's no problem to put AI into the rules of the GDPR. So I think it's a perfect suit for the baby, for your baby, if you take the AI, and so you can put it in there without any troubles.
And we're still waiting for the baby to be delivered, so I think you have to accommodate. Things are going to move in a direction. We're not going to stop them, and I'd rather be ahead of them than behind them. And so I suspect California is going to do everything it can to be as close, if not ahead, of whatever the movement is, whether it's AI or anything else when it comes to this new digital world.
One of the key recommendations we've talked about in terms of emerging technologies on the Internet of Things, and the Aspen Cybersecurity Group issued a recommendation on that front. In the California law, there's a discussion of that companies need to develop reasonable security features that are appropriate to the nature and function of the device. That's also a focus of our recommendation, is that we want to encourage security by design. That is not currently defined. We have many experts here who could help define it. Could you tell us where you are on defining that standard, and if you think there's productive ways that people in this audience could help?
We just reached a settlement with Uber on one of its violations, its breaches, and one of the conditions in that settlement was that they had to move towards this new paradigm where in the design of every function that they put out there, they are taking security into account. So security by design is now one of the conditions that's been imposed upon Uber when it comes to how it interacts with its consumers.
And do you see that more in the province of privacy or the security function?
The GDPR provides privacy by design and privacy by default. And if you take this into account from the beginning on, you're on the safe side because GDPR promotes privacy by design and privacy by default. You need it.
I think that I know there are a lot of questions in this area, so let's open it up to see if there are questions from the audience. And do we have a microphone? There we go. While we're waiting, there's privacy by design, and then there's also the EU is working on security rules. Do you see a difference between privacy by design and security by design, and what would it be?
I think it's very important to have a look on both sides, not only on one side. And security by design and privacy by design are different things, but both important for the functioning of both.
And by the way, I think I said security by design. I meant privacy by design.
Yes.
Thank you. My question is for Attorney General Becerra. Under the current standard, under the California law, the penalties if you suffer a data breach are pretty high. You know, it's $100 to $750 per violation. So if you're a company who has millions of customers in California, that can be billions of dollars in fines. And they don't really take into account the fact that, maybe you never walked into a room with baby snatchers. You held your baby close to your chest constantly.
We're going to really use that metaphor.
I think it's a great metaphor, and I actually have a 3-month-old baby at home, and I'm thinking about all of the
I hope you never drop your baby now.
I've never dropped my baby, and all of the things that my wife and I do to keep our baby safe. Yet it's possible that someone could break into our house despite the security, the alarms, the bars, and snatch our baby.
Yeah.
Do you think that we should pay that $1 billion fine or be charged criminally the same as someone who walked into a room full of baby snatchers? And if not, what do we do about that? How do we take into account that many companies, including mine, are spending millions of dollars and hours trying to do the right thing, but could still suffer a breach, even though we put the best practices in place?
Yeah. And I think most laws are written so that violating them, committing crimes, if they are criminal, cannot become just a part of doing business. That you can accept the fine as just a part of doing business, and you can write it off as that. It has to sting enough that it makes you change, and it makes everyone else open their eyes to it and deter them from having that happen to them. And so most of the time, these fines, they speak to amounts that are up to that level. But I challenge you to find many cases where a settlement or a court judgment has reached the upper limit of those eligible fines. And so that's where there's discretion, and ultimately what you're trying to do is deter future conduct, but also punish the bad behavior.
While we're waiting, when under the California law, before rules are regulated, it asks for public participation. You're getting some today.
Yes.
But I was wondering, is there a timeline? When do you expect to get that public participation more officially than our forum?
We're getting lots of feedback, comments already. We hope to launch more public efforts beginning early next year. But people shouldn't wait. A whole lot of stakeholders have already been getting us information. I want to make something really clear. The California Department of Justice does a lot of things. Most of them in the enforcement space. We're not your typical regulator. We're being asked now to be a regulator and an enforcer in this regard. And so it is... it's a big endeavor, and you have some good insights, come on down.
One of the challenges with these laws is keeping up with technology, and I'm curious in both in the EU and in California, what is your vision on how these regulations will change as technology changes? I mean, the appropriate vagueness of the California law, appropriate for the application, seems good in general, but how do you make that work in real? And it's a question for both of you, really.
Okay, shall I start? Okay, as the GDPR entered into application 5 months ago, you know we have a new EU body, and the new EU body is the European Data Protection Board, which consists of all the 28 data protection authorities, and we are already used to work together as an advisory body, but now we are a decision-making body, and we have to look after the uniform application of the GDPR all over Europe. That's one of our duties. Another duty is to give guidance to companies regarding the GDPR, what about the special provisions of the GDPR, which we already did. There are already issued 18 guidelines regarding specific topics. And the third, amongst others, the third is we are decision-making as an arbitration body. If there are, regarding a cross-border case, if there are differences between the lead supervisory authority and a concerned supervisory authority, then the board is at stake to make the decision, and the decision will then be transposed into the national law of the lead supervisory authority. And so we are working together on this point. But to make it clear, if there are fines, and in Europe it's not like that all investigations result in a fine. There can be warnings or reprimands too. And so one of the very important things is that the fine has to be proportional. It's not a question if there are 20 millions or 10 millions. It has to be proportional to the infringement and to other things which are laid down in Article 83 of the GDPR. So it's not only a question that the eventual fine is dissuasive, it also has to be proportional. And this is really important to make this distinction.
And because I agree with much of what the chairwoman said, I'll just, again, sort of put it the way I started. The four corners of privacy in this space, to me, are control, choice, transparency, innovation. So you got to make sure individuals get to control that private information, that data. They make the choices. They can make informed choices because there's transparency. But at the end of the day, if you don't have innovation, there's not going to be a whole lot of data that you have to worry about giving out, because we're going to be so far behind the times that everything's going to be done by others for us. And so I want to make sure that California, we continue to lay some golden eggs. And that requires us to be innovative and allow that innovation to feel it's got space. Four corners.
Hi there. Question for the Attorney General. I'm wondering what you think of two recent developments. The first is the legislation being proposed by Senator Wyden from Oregon about the that would basically make it would impose criminal penalties on executives who had violations within their companies. And then two, Intel, I guess, has written some legislation that they're looking for a sponsor for, which I think would address the question that the gentleman with the 3-month-old asked. And I think what they're saying, if I understand it correctly, is that if you are a company and you have met certain requirements that the government has laid out, that you would then be immune from fines. I don't know if it'll go anywhere, but just it's being thrown around, and I'm wondering what your view is on both of those.
My most direct response is I've been an enforcer now for almost 2 years. I was a policymaker in Congress for 24. I suspect by the time we see something actually pass Congress and get signed, it'll be more than 2 years, hopefully not 24. But I suspect Senator Wyden's proposal will get a lot of consideration. Ultimately, what can become law, I think, is far away. And so meanwhile, we have an opportunity to provide input, learn from what Europe has done, hopefully learn from what California will do to inform Senator Wyden and all the members in Congress who are going to try to put together a bill to perhaps give us a national standard. But I don't expect that you're going to see something fly through this upcoming Congress.
Just as we go, if there was one thing, I'll ask each of you, that the United States should do federally, recognizing things don't always fly through, but what's the top priority? Is there one thing on your wish list that you wish they would do, as soon as they convene in January?
Function. Madam Chair, you better take this.
I would never dare to give advice to the legislator of a foreign country, but we are ready to share our experience. And if you want to ask us, we are ready to share our experience, but never advice.
Other questions from the audience? It's hard to see, but I assume, given the number of questions that you have asked me to ask them, it's hard for me to believe there are not additional questions. Can we give immunity that no one will suffer an enforcement action because of their question today?
No, we can't. No, I'm just kidding.
So we're going to nourish our babies.
Yes.
While we wait, following up on that, but you were asked to come to Washington, D.C., yes?
Yes.
To give the experience of GDPR just recently. Were there some key lessons that you provided when you met with officials in Washington?
I already said I would never dare to give key lessons, but I
Things
provided,
you learned,
I
not lessons
provided-
for them.
I
Yes.
provided some information regarding the functioning of the GDPR and how we experienced the working, how we experienced the start of the working of the GDPR. And the most interesting was that the preparation for the 25th of May all over Europe, because this was the date when the GDPR entered into application, was like that. It was exhausting. It was really exhausting, and everything was very important, and everybody thought, world will stop on the 25th. But no wonder on the 26th, world was still spinning. And it was not the end. It's just the start of a very interesting common journey we are going to do with the GDPR, with the companies, with our partners from all sides of the oceans. And I think it's really important to keep into dialogue and to share our experiences and just to stay in contact, and for the companies to be compliant if you want to make business in Europe.
Yes. And speaking of complicated tasks that will not be done on day one, do you expect to ask the legislature for some additional time on the rulemaking or further extend the operative date once they reconvene in January? As you referred to before, you have a heck of a lot on your plate under this new statute.
So I thought we might get there, so I brought a copy of the letter I sent to the legislature on August the 22nd. I won't read it all. It's about 2 pages, but the first paragraph, after saying nice things, says, I appreciate your leadership and share your commitment in protecting consumer privacy and the goals of the CCPA. However, as I have warned before, the CCPA imposes several unworkable obligations and serious operational challenges upon the Attorney General's office, the agency charged with its oversight and enforcement. And as I have stressed on numerous occasions, failure to cure these identified flaws will undermine California's authority to launch and sustain vigorous oversight and effective enforcement of the CCPA's critical privacy protections. The letter goes on to point out the areas of the new, then the legislation's areas of concern, and part of it was some of the language would be difficult to actually implement and enforce. Part of it was the resources that it would take for an enforcer to start doing a regulator's job, and part of it was the horizon under which they expected all this to happen.
Maybe linked to that, do you expect to issue the rules all at once, or are you going to hit priority areas and do it in a piecemeal approach, and then maybe afterwards you could comment on your similar experiences with GDPR?
The answer is yes,
Yes.
which means
Don't know.
we'll find out. As we move through the process, depending on all the information we gather, that'll give us a clear sense of where to move. But to speculate at this stage where we're going to end up, how quickly, and how, it's anyone's guess. But I really do urge all of you, if you have some good thoughts, really chime in.
We'll take maybe one last question and then wrap.
There's already been a lot of criticism by some of the major technology companies here in California. How do you want to avoid that via lobbying the California data protection law will be significantly watered down? Because those efforts will be undertaking in the next couple of months, right?
It's a part of the process to have everyone weigh in. There's nothing wrong with it. There's stakeholders on all sides. And quite honestly, that's the way it should be in a democratic process, where you get everyone chiming in, and you hopefully, as I said, you hit the sweet spot. And so the more we get from all sides, the closer we can sort of discern that sweet spot. But, you know, some people have more capacity to lobby than others, and that's where the concern would be that some voices would be ignored or not heard. And I hope you help us do a good job of making sure we're hearing from everyone. But my sense is that we'll get to that sweet spot if there's a robust process that lets us get to the point where Europe has already gone. And then we'll be looking at what GDPR is unfolding in Europe to help us. So we'll try to learn from the best practices that are out there and learn from the comments we get. And as I said, we're newbies in this as well.
Well, I want you to join us in thanking two of the most important voices in the world that will be shaping what companies do and how our information is protected. So please join me in thanking them for joining us today.
Thank you.
Thank you.